Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 125. I thought we'd do a slightly different episode this week. This is inspired, if that is the right term, by the fact we've had both the outcome of the Uber appeal and also the Deliveroo decision to mull over. It also comes alongside a couple of other interesting developments on the question of employer-employee relations, worker status, etc. So this week we're looking at the Deliveroo decision, the Uber decision, and a CAC union recognition claim which has just been launched against the University of London, and then ask, what does all of this mean? Before going any further, I would like to give a shout out to the listener who pointed out that one of the links that we were using for the podcast a couple of episodes ago wasn't working. Thank you very much. Genuinely, we do really appreciate that people take the time and trouble to email in. His Twitter handle, coincidentally enough, is FitBloke35. So thank you, FitBloke35. I don't have a name to go with that. It did also strike me, however, just how close this is, or should be, to my own Twitter handle. Because, quite genuinely, after the amount of client entertaining, etc. that I've had to do in the last couple of weeks, FatBloke53 would be an entirely appropriate handle for me, rather than the more prosaic Nicholas Robertson at Nicholas ROBER11, which I was given by the firm when they set up my Twitter account. Perhaps I could investigate a name change. Anyway, on to business. So, Aslam and Farah against Uber, BV and others. Obviously, we dealt with the initial tribunal decision in an earlier podcast, so what I'm doing here is summarising the facts and then go on to talk about the EAT decision. The basic case, well, obviously a number of Uber drivers have brought claims arguing that there was a failure to pay them the minimum wage, a failure to provide holiday for them, and also there was a suggestion, as yet entirely unarbitrated on, that there are some whistleblowing claims in there too. The preliminary hearing at the Employment Tribunal focused on the status of the individuals. Obviously, status of the individuals is important because if they're looking to claim the right to annual leave, national minimum wage, etc., they needed to show they were employees or workers. And in practice, as I'll go on to explain, the only way they were going to succeed is showing they were workers and relying on the facts of this case as found by the Employment Tribunal and then challenged at the EAT stage. In order to explain, it may just help just once more to go over the definition of a worker, which is obviously the halfway house category between being an employee, someone who works under a contract of service, and someone who is self-employed and or in business on their own account. For there to be a worker relationship, there needs to be a contract under which the individual performs work personally for another party to the contract, where the individual is not carrying out a profession or business on their own behalf. In other words, there needs to be a contract, there needs to be a requirement for personal service by the alleged worker, and when you look at the relationship between the alleged worker and the alleged employer, the alleged employer is in fact not the employer, but is a customer or client of a business undertaking run by the individual. Now, Uber in London operates through two separate companies. Uber BV is the parent company. It has the rights to the Uber app. It is based in Holland. Uber London Limited operates in London, and according to the contractual documentation, Uber London is the agent for the driver. The documentation asserts that Uber London does not provide a taxi service for a customer. Uber's London's documentation says the contract for the provision of the taxi service is between the driver and the passenger. Uber seeks to position itself solely as being a technology platform facilitating taxi services. It was accepted by the Employment Tribunal that drivers had complete freedom to choose whether or not they wished to work on any given day. However, if they were interested in receiving work, they needed to log into their Uber app and then be available to take passengers. The whole passenger process is closely controlled by Uber. Uber allocates passengers to drivers, and through the app, Uber puts the passengers and the driver into contact. The driver is not told where he or she is going until the passenger has been picked up. It's a bit like the London cab rank rule, and it's presumably for the same reason. The app offers route guidance, but it's up to the passenger what route to take. The driver is not allowed to charge more than the Uber recommended fare. The fare itself is paid directly to Uber BV via the app, and Uber BV then account to the driver less a service charge for the fee. At the employment tribunal stage, it was accepted that the drivers were providing a personal service. This was not one of those worker status cases where the individuals concerned could provide a substitute in reality or in theory. Here, drivers were accepted personally by Uber, and so they were providing a personal service. The right for them to use the app, for example, was a personal right, could not be transferred to anyone else. The claimant's case was that Uber, and in particular Uber London, were able to control the drivers sufficiently to enable them to be found to be workers working for Uber London. The passengers were not the customers of the driver, but customers of Uber, according to the claim. The Employment Tribunal honed in on the AutoCleanse case, in which the Supreme Court found that if terms did not reflect the true agreement between the parties, then the court could identify what it said was the true agreement. The suggestion in AutoCleanse was that armies of lawyers would simply place substitution clauses or clauses denying any obligation to provide or accept work into employment contracts as a matter of form, even when such terms do not begin to reflect the real relationship. I'm going to come back to that point, but in essence, here the Employment Tribunal had found as a fact, and in strong terms, documentation did not reflect the reality of the relationship. They said things like the fact that Uber is not a mosaic of 30,000 small businesses linked by a common platform, that was faintly ridiculous. Well, at the Employment Tribunal stage, having decided that individuals were workers, the Employment Tribunal then had to just look at the working time and when were the workers actually working, for the purpose of then enabling a comparison to be made to establish whether or not individuals had been deprived of the national minimum wage, rest breaks, holidays, etc. Tribunal decided that both for the purpose of working time and under the national minimum wage, individuals were working when they were in the area where they were also authorised to drive and had turned on the app, indicating they were willing to work. This crucially meant time spent waiting on duty for bookings counts as working time. So, how did Uber get on in the EAT? Well, there were a number of grounds of appeal. Some of these related to agency law, and bear in mind that Uber was seeking to position itself as the agent of the driver when it came to the provision of services, not the other way round. Uber said the agency relationships here agency relationships were similar to, and indeed a regular feature of the private hire vehicle sector. Uber pointed to various cases where, for example, minicab drivers had been found to be self-employed. Equally, Uber claimed that some of the features which the Employment Tribunal had relied upon to see the drivers as workers were in fact regulatory requirements rather than a matter of choice for Uber, and as such should not form part of the factual matrix when it came to assessing worker status. Uber also asserted that even if individuals were workers, they were not workers unless they were actually driving. The waiting time by drivers should not count as working time, and therefore be subject to things like the national minimum wage. The EAT dismissed Uber's appeal. They felt the key question was when the drivers were working, who were they working for? So they deferred the question of when were they working. The EAT starts with the who are the drivers working for. The difficulty for Uber was the Employment Tribunal had found as a fact that the documentation drawn up by Uber was not in line with the true position. Try as Uber might, it couldn't get past that finding. And once that finding's upheld, it's much more difficult for Uber to challenge the Employment Tribunal's decision. The EAT said that the degree of control and integration into Uber's business justified or enabled the tribunal to find that individuals were workers rather than self-employed. The scale of Uber's operation was a factor in this. Drivers who were genuinely employed, for example, would be able to grow their businesses. That wasn't possible here. They had no real business relationship with the passengers. They could not negotiate terms, and Uber's terms were simply given to the drivers on a take-it-or-leave-it basis. Even the regulatory issues, which Uber had said had been taken into account unfairly in evaluating the relationship, could form part of the context, according to the EAT. Moreover, the EAT pointed out that the regulatory environment did not require Uber to treat the drivers with the level of control it had over them. So, the EAT, having found that the drivers were workers, went on to consider when the individuals were working. The court accepted this is a much more difficult question because there was some evidence to indicate that while drivers were waiting to pick up an Uber passenger, they were free to pick up passengers for other hirer companies. As such, it was an odd concept for them to be working for Uber when they were waiting, perhaps equally, for work from another competitor. However, for the EAT, this is a question which would be determined on the facts. Here, for example, it was clear that there was some disincentive for drivers taking on other work in the waiting period. drivers logging on as available for work and then not actually picking up the work that was offered to them because, for example, they were working elsewhere, could have their access to the app cut off for a period. In short, for all of the excitement generated by the EAT and what appears to be a relatively hard-fought appeal, where Uber clearly pulled out all the stops, the Employment Tribunal judge's decision survived in full. I think it's fair to say the expectation is that Uber may look to appeal. Indeed, this case might go straight to the Supreme Court. I've heard it suggested it could be listed alongside the Pimlico Plumbers case in February. We covered that in an earlier podcast too. I doubt very much whether we've heard the last of the Uber case. So, that's the case of Aslam and Farah and Uber BV and others. Next up, Independent Workers' Union of Great Britain and Roo Foods Limited. In the run-up to this case, which is of course the Deliveroo case, I suspect that if you did a poll of most people involved in employment law one way or another, then it would have been assumed that the Deliveroo case would be entirely in line with the gig economy cases in the UK in finding that individuals were not genuinely self-employed, they are workers. The CAC was the battleground for this particular case because the union was testing the status of the individuals and whether or not they are workers by means of an application for union recognition. It is only possible for a union recognition application to be granted in respect of workers or employees. So this provided a clever way of testing workers, the status of workers for a group of individuals in the form of a single action. Now, much to the surprise of the outside world perhaps, this claim has failed, at least at the CAC stage. So how come Deliveroo is contracting with self-employed individuals and Uber is contracting with workers? The answer is, unsurprisingly, that not all gig economy employers are the same. Drivers apply to Deliveroo and are given an interview and undergo things such as criminal checks and a trial shift. They get food hygiene and safety training. They get given personal access to a smartphone app, which allows them to show whether they are available, for work, and whether they are unavailable for work. Jobs can be taken on by drivers, but the driver can then reject them subsequently. There's no penalty at any point for turning down work. Now, the Deliveroo documentation under which they work is very clear. They are independent, self-employed individuals and they have to pay their own tax and national insurance. There is no obligation on them to undertake any work for Deliveroo at any time. Similarly, Deliveroo is not under any obligation to provide riders with any work. It is made clear that they are fully entitled to work for competitors. There is no requirement to wear Deliveroo uniform or kit. Indeed, it became clear that riders were entitled to wear competitors' uniforms while working for Deliveroo. There would be no sanctions. The rider documentation stated they could provide a substitute rider at any point for any reason. The fact of substitution did not even need to be passed on to Deliveroo. There are only a couple of categories of individuals who were not permitted to act as substitutes. For example, individuals who had previously been terminated by Deliveroo for a material breach of their obligations. The rider was responsible for what the substitute did. The rider was the person paid by Deliveroo in all cases, and the terms of any subcontracting deal between the rider and the substitute rider were a matter for the rider and the substitute, not for Deliveroo. The CAC found that the requirements for union recognition were met, all of them, apart from the issue of worker status. So what was different about this case from the Uber case, which we've just been talking about? Well, first of all, it was accepted here that there was a contract directly between Deliveroo and the riders. The riders were not carrying on business on their own account, according to Deliveroo. So, Deliveroo was not suggesting that it was simply a contact platform putting riders in touch with potential customers. Deliveroo's case hinged on the substitution clause. As I said, there were clear provisions allowing almost entirely unfettered substitution by Deliveroo riders for any work. And here's the crucial difference. In the Uber case, the tribunal found that the documents did not reflect the realities of the situation, and the tribunal was therefore able to look behind these and determine what it said was the commercial deal. Here, the CAC made no such findings. They identified the fact that it was very odd that Deliveroo would go through a relatively rigorous screening and training process for riders, but then permit riders to substitute other riders to undertake the work. Subcontracting could go to people who've never been trained or screened. The union's case on behalf of the riders was that this showed the substitution clause was a sham. There was no commercial reason for it. But Deliveroo's response was that, at the end of the day, that was a matter for Deliveroo. And if there were regulatory or reputational risks associated with allowing an unfettered right of substitution, that did not alter the fact there was an unfettered right of substitution. Furthermore, Deliveroo was able to give evidence to show the substitution clause was used in practice. It conducted a survey in one of the regions affected as to how many riders had used the subcontracting clause. They surveyed 65 riders, and 14 of them had either used a substitute themselves or knew other riders who used substitutes. And the best bit of evidence, I suspect, from Deliveroo's point of view, seems to have been one driver who admitted subcontracting his work and then taking a cut of the fee before handing the balance over to the substitute. So, on that basis, there was a clear right of substitution and clear evidence that it was used in practice, albeit perhaps by a minority of riders. Therefore, the CAC accepted there was no duty of personal service, because drivers could substitute, and at that point, the individuals were self-employed, not workers. So, that's why this case was different from Uber, or indeed City Sprint, where there was no unfettered right of substitution. So the message at the moment seems to be that a genuine and unfettered right of substitution, if exercised in practice and contained in the contractual documentation, seems to be a much better way of defending worker status cases than trying to argue someone is in business on their own account. But it may well come at the cost of somewhat reputational risk for a gig economy like Deliveroo, with its customers may be surprised to learn that the person delivering their food late at night is not actually connected with Deliveroo. Well, that's the case of Independent Workers' Union of Great Britain and Roo Foods Limited. And talking of Roo Foods Limited, do read the full CAC decision, if only for some truly terrible puns used by Deliveroo in its dealings with its employees. Gosh, I nearly said employees, with its riders. The idea that the communication that goes out to staff, to use a neutral term, is a ruse letter, is merely just one of the terrible puns. The third case also features the International Workers of Great Britain, and in this case is against the University of London. By contrast to the other two cases, this case is right at the beginning of the history. Yet in some ways, perhaps, it has the potential to be much more radical if it succeeds. Should I emphasise right up front, we've had no involvement in this case, and I'm taking the report of the claims from what was statement was put out by the union concerned, and stories that have appeared in, for example, Guardian, BBC, etc. The application concerns workers who are outsourced from the University of London. It is asserted, I have no way of knowing whether it's true or not, that their wages are worse and their treatment is worse than if they were directly employed by the university itself. I'm sure this will be contested. It's also asserted, and again I'm sure equally it'll be contested, that the university disclaims all employment responsibilities for the individuals who are working for another organisation, i.e. the outsource operator. The outsource operator, it is alleged, also denies all responsibility for setting T's and C's and says they are in effect set by the university itself. It's reported the claim is based on the legal status of the employment relationship for those outside workers, and it's asserted that they are jointly employed by the outsource operator and the University of London. The mechanism by which they are challenging this is through the Central Arbitration Committee again. They say they are entitled to collective bargaining rights with the University of London on the basis that the true situation is that they are not simply employed by the outsource operator, they are also employed by the university. The means to test this is an application for union recognition and collective bargaining rights against the university. Well, conventional legal wisdom will say this is most unlikely to succeed. We know from cases such as James and Greenwich Council that attempts by agency workers to argue they are employed by the end customer rather than the employment agency have tended to fall on deaf ears. Broadly speaking, and this could fill an entire podcast on its own, I should say, the courts take the view that if the situation on the ground is adequately explained by the existence of the purported contract between the agency and the agency worker, then there's no basis for implying a contract between the agency worker and the end customer. I think outsourcing would be in a very similar vein on the conventional legal view. So on that basis, the university has nothing to fear? Well, of course, if the university did lose and joint employment became a concept regularly recognised in English law, and it is recognised in various countries in Europe as a perfectly valid legal concept, this would affect, potentially, the whole outsourcing industry quite significantly. Although in many cases outsourcing is intended to achieve operational efficiencies, one of the ways in which it does this, of course, is to encourage close scrutiny of the wages for the employees working in that particular part of the operation. It's not the only rationale for outsourcing an operation, of course, but if you've got competitive bids to run an operation, naturally the employees' wages can be a hefty cost in many cases, and that's an area where they look to make savings. If the law is firmly against the existence of dual employment in this case, you can see why employees may feel they are effectively being left without a remedy. So, if the legal claim is I'm saying, imaginative, why bring the claim? Well, first of all, courts are showing themselves as increasingly open to look at the economic realities of the working relationship. The AutoCleanse case, which I've mentioned already several times in this podcast, shows that courts can disregard perfectly valid and apparently correctly written contracts of self-employment if the true situation is that the ostensibly correct legal arrangement is a fiction. I still think it's a bit of a stretch, though, to go from that to say we're going to moving from recategorising an admitted contractual relationship, self-employed versus worker, to going to saying, well, you have a contract between A and B, but we're going to invent a contract between A and C instead. By creating a contractual relationship with a party who's not even in a contractual relationship, that seems to be taking this a step further. Secondly, on the fact, is the customer of an outsourced operation really in an employer-employee relationship with the agency workers? If they've handed off responsibility for an area of operations and leave it to the outsourced operator to get on and manage and recruit and pay and dismiss whatever, in what sense are they actually operating in an employment relationship, I wonder? Obviously, I'm sure in the CAC case there'll be two sides to the story. There might be another angle to all this, of course. It may well be that this claim is brought in the knowledge that legally, as the law stands at the moment, it is unlikely to succeed. But it is easy to see that if there's a change in government, or indeed if this government felt sufficiently embarrassed by what came out of the factual situation, the legal claim, and any campaign run by the union, there could be a change in the law. This might be what is intended. By analogy, and in different circumstances and some 20 years back now, the introduction of the Disability Discrimination Act might be a precedent for this. We were asked to do a case by a client before that act was even dreamt of, and it was defending a claim which had been brought under the Disabled Persons Act 1944. Broadly speaking, certain jobs were reserved for disabled employees, but the legislation also put some very light obligations on employers in connection with disabled employees. One employee, Carol Perry, brought a claim saying that even those light duties had not been complied with in her case. The case went to a hearing, she lost, and then she brought judicial review proceedings, arguing that the decision not to uphold her claim had effectively been predetermined as a matter of policy, and no claim would ever be permitted to proceed under the Disabled Persons Act 1944. In response, as part of that application, John Major's government confirmed this was not the case, and shortly afterwards introduced the Disability Discrimination Act. Although I was representing the company in that case, so I don't know whether that thinking formed part of Miss Pirry's thinking. There's no doubt that her campaign and her claim was followed very shortly afterwards by the introduction of the disability discrimination legislation, largely in the form that we know it today, and obviously significantly stronger than the earlier Disabled Persons Act. And, by way of brief anecdote, the case also taught me that it is quite okay to tell a client you've not done a particular type of claim before. The company in question called me out of the blue, and someone had given them my name. The HR director asked whether I'd done any cases under the Disabled Persons Act legislation. I said I'd read about the legislation, but I'd never done any cases under it. He said, fine, I know you're telling the truth, because there haven't been any cases at all on this in the United Kingdom in the last 25 years. But on the basis that you're prepared to admit you haven't done any cases, you can do this one. So, honestly, it sometimes pays. There's a shocking thought. Anyway, I think on that basis there must be a chance here that there will be a political campaign around the litigation as well, to shine a spotlight on some of the alleged abuses in the outsourcing system. Equally, though, is it so far-fetched to think that a potentially activist Supreme Court might want to take a look at the realities of the economic situation here? I'm not convinced that if they did, the union will still win. It's certainly a claim that would deserve to be taken seriously. The other thing that's happened this week, and I'm conscious this podcast is a bit longer than normal, but I did want to mention it, it's directly linked to worker status cases and the world of work generally. This is the Select Committee on Work and Pensions, which published a report on the gig economy, building on the Taylor report. The committee has also put together a draft bill designed to try and improve rights and, in its own terms, quote, ending the mass exploitation of ordinary hard-working people in the gig economy. And I think they estimate something like 1.6 million people work in that economy. The draft bill starts off with a clause providing for a presumption that individuals are workers rather than self-employed, and leaves it up to and then would put the onus on the contracting company to prove that individuals are self-employed. They also follow up the suggestion in the Taylor report that individuals should be provided with clear statements about their status at work and the legal rights and entitlements that go with that status. Interestingly, the report and the draft bill also suggest that class action should be part of the employment tribunal landscape to enable tribunals to apply their rulings beyond simply the individual claimant in front of them. Now, I don't know whether any of this will make its way into legislation or whether the government will respond in turn both to the Taylor review and this draft bill. It does seem, however, that the issue of worker status and the effective functioning of the employment market is a challenge, and it's an idea that is here to stay. I would be very surprised if there isn't significant change within the next 2 years, somewhere in this sector, whether worker status or more generally. I also think, and speaking entirely personally I should emphasise, that the idea of class actions in employment tribunals is long overdue. The difficulty is relying on enforcement by individuals, because of course it requires an individual claimant who has sufficient courage and fortitude to withstand the tribunal process, even assuming they have financial support from, say, a union. Secondly, it's all too easy for a gig economy employer to simply alter the terms of engagement sufficiently to require a further case to go through the system on worker status. And of course, that game can be played indefinitely. Also, some gig economy employers might take the view that it is better to dismiss the troublemaking claimant and thereby discourage others from bringing claims, even if ultimately they end up having to pay out a certain amount of money to the person dismissed. A system that allowed tribunals to spread their rulings to cover all those incomparable situations would bring about far more change and probably put more pressure on gig economy employers to comply with employment worker status rights in the first place. I was surprised this idea didn't feature in the Taylor report, and I am, as I say, on a purely personal basis, pleased to see that it seems to be getting an airing in the Work and Pensions Committee draft bill. Anyway, that was the case of the International Workers of Great Britain versus the University of London. So, there we are. That's the end of what is a longer than usual podcast, so thank you very much for listening. 2 quick points, perhaps. First of all, between podcast 124 and 125, we did a podcast with Liz Stern, talking about international mobility. Do please listen. It's a really good podcast. Liz is a great guest, which is why she keeps getting invited back on the podcast. And what she has to say is interesting and pertinent for all employers. Secondly, last week marked a significant milestone in my life because I worked out it was my 200th gig that I've been to. So the link being gig economy, that we're talking about musical gigs, of course. And I saw Rhiannon Giddens, and she was fabulous. No surprises there. But yes, 39 years of going to concerts, and I'm up to my 200th gig. So yes, next year 40, and it would be quite nice if I could go see Squeeze again next year, because they were the first concert I ever saw 40 years ago. Mothering Sunday 1978. There's a thought. All right, thank you very much for listening. Stay safe, everyone, and until the next podcast. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.